Morning to everyone present. My name is Jimena de la Villa. I am an associate at Bullard Faye Escurra, and on its behalf, it is a pleasure to be hosting this international event with the collaboration of the Singapore International Arbitration Center. Today, our keynote speakers will address the advantages offered by SIAC in the administration of international commercial and investment arbitrations, as well as discuss their previous experience on scrutiny procedures in order to compare it to the Latin American and specifically to the Peruvian scenario. On that note, the main purpose for this event is for our speakers to tackle the frequently asked questions on the subject and therefore assess how any international arbitration center can administer properly a scrutiny process. Now let me introduce our speakers. First, Professor Born. He is the president of the SIAC Court of Arbitration and chair of the International Arbitration Practice Group at WilmerHale. He is one of the world's preeminent authorities on international commercial arbitration and international litigation, who has been ranked as one of the world's leading arbitration practitioners for the last 20 years. Also, on behalf of the Singapore International Arbitration Center, Mr. Kevin Nash. He's the Deputy Registrar and Center Director, who has overseen the administration of over thousands of international arbitrations under the SIAC rules and UNCITRAL rules. He is also a member of the Singapore delegation at UNCITRAL Working Group 2 and represents SIAC as an observer at UNCITRAL Working Group 3. On behalf of Bullard Faye Escurra, we have its senior partner, Alfredo Bullard, who is a world-known arbitrator specialized in commercial and investment disputes, with experience as co-arbitrator and chair in over 300 arbitration cases, and has been recognized this year as one of the most in-demand arbitrators by Chambers and Partners. Last but not least, Huáscar Escurra, also partner at Bullard Faye Escurra. He is a recognized arbitrator in commercial arbitration disputes and is currently a member of the board of the Arbitration Center of the Chamber of Commerce of Lima. He has also been recognized as Band 1 on dispute resolution arbitration by Chambers and Partners. Now, without further ado, we will begin with the SIAC's presentation. So please, Mr. Bourne and Mr. Nash, you have the floor.
That's great. I think, thank you so much for that very kind introduction, Jimenez, and I'd like to thank in particular Alfredo and his partners for the invitation for Kevin and myself to be with you all over Latin America, all over the Americas this afternoon. I believe Kevin is going to share some slides. It may take a moment for share screen to come on. But let me say a few words by way of background for those of you who may be less familiar with SIAC, with the Singapore International Arbitration Center. We're a relatively young, not a teenage, but a relatively young arbitral institution. We celebrated our 25th anniversary just a few years ago. And over that time period, as you can see on the current slide, we've experienced very rapid, very successful growth in our caseload, but also in all other aspects of the institution's operations. Sometimes people think that because SIAC is located physically, at least in part, in Singapore, that we're a Singaporean or a Southeast Asian or Asian arbitral institution. That's wrong. We do have, of course, very close connections with Singapore, with Asia more generally, and expertise, knowledge about that region in particular, but we are a global arbitral institution. It makes as much sense to choose SIAC to conduct an arbitration, to administer an arbitration between a Peruvian and Mexican or Chilean and US party as it does between a Chinese and an Indian or a Vietnamese and a Brazilian party. We're a truly global, truly international arbitral institution. I'm president of the Court of Arbitration, an honor that I've had the privilege of holding for the past several years, 4 or 5 years. And together with 30 or so other practitioners, both from Latin America and elsewhere around the world, we at the Court of Arbitration appoint arbitrators, resolve a limited number of initial procedural issues, such as whether or not to conduct expedited procedures or consolidate or permit intervention in cases. We also hear challenges to arbitrators. In addition to the Court of Arbitration, there is a board at SIAC, which is responsible for the basic business affairs, the landlord-tenant relations and that sort of thing of the institution, and a registrar's office or secretariat. Kevin is the deputy registrar and head of the SIAC office in Singapore. The registrar is responsible, as Kevin will explain in greater detail, for much of the day-to-day case administration. Obviously, the actual decision-making, the conduct of the arbitrations under SIAC rules is in the hands of the arbitral tribunals, the arbitrators that we in the Court of Arbitration or the parties select. But SIAC, the registrar's office, is responsible for a number of other additional features of the case administration, setting the advance on costs, scrutinizing the award, as we're going to consider in some detail, corresponding with the arbitrators and the like. As you can see on one of the slides, perhaps we can go back, Kevin, just a couple slides to one of the first slides that's in our slide deck. SIAC's caseload has grown very substantially over the past 25 years or so. We reached nearly 500 cases last year. They were broken down, as you can see on the next slide, between administered cases under the SIAC rules, 554 of those, and 25 non-administered cases, cases where the Singaporean arbitration legislation gives us responsibility for selecting the arbitral tribunal. The caseload that we've experienced has grown very dramatically over the past years. As you can see, in the past 5 years, it's probably more than doubled in size, and it all arose from a very small beginning, an acorn that led to the current oak tree that is reflected in our case statistics. But in the first few years of our existence, there were only a couple cases per year. Our principal users, our main foreign users, you can see on the current slide, they involve parties both in Asia. India and China are obviously significant representatives in the nationalities of the parties that we have, but also other jurisdictions, the United States, Europe, other jurisdictions in Asia, whether Malaysia, Indonesia, Japan, Korea, other jurisdictions in the area. But as I say, the United States, North America, as well as Europe, the United Kingdom, other European jurisdictions figure very prominently among our users. You can arbitrate essentially any kind of commercial dispute under the SIAC rules. You can see a rough breakdown in the types of disputes that we had last year in 2019, broken up fairly proportionately between commercial cases, shipping cases, construction cases, increasingly intellectual property cases. I should emphasize that the COVID-19, the pandemic, has had virtually no negative impact at all on SIAC's operations. Although some people work from home, the office is open several days a week, and parties have continued to file requests for arbitration, and arbitrations have been conducted in accordance with the SIAC rules by arbitral tribunals, often with remote or hybrid hearings. I can assure you as well that the number of cases that we are seeing filed is significantly above that at this point last year. This will, by no question, be our busiest year ever. You can look at some of the other aspects of SIAC arbitrations. The current slide has the geographical diversity of arbitrator appointments. We appoint arbitrators from dozens of jurisdictions all over the world. Often, of course, the appointment of the arbitrator depends upon the choice of law provisions that the parties have included in their underlying commercial contracts. If the parties have selected Singaporean law, as sometimes happens, English law also happens, frequently the arbitrators will be from those jurisdictions. Equally though, if Parties are from a civil law jurisdiction, Latin America, elsewhere. There are a number of civil law jurisdictions in Asia, and we have a significant number of case filings from Europe. We appoint civil law qualified arbitrators. Unlike some arbitral institutions, in particular the International Chamber of Commerce, who we see as our principal competitor, we are entirely transparent about our selection of arbitrators. The choice is not made by some unidentified national committee. Instead, it's made by the Court of Arbitration, by myself, the vice presidents, or by the registrar in default. The choice is not made from some secret list or random ad hoc collection of names. Instead, it's made from a panel that is published on our website and which has a formal process for applications. Incidentally, I would encourage all of you who are watching this to think about submitting an application to us, to SIAC. There's an application process identified on our website to be included on our panel of arbitrators. We're always anxious to find, we're always looking for highly qualified arbitrators, and in the coming years, we expect to be seeing significantly more case filings from Latin America, from the Americas generally. Finally, we've also made real efforts to increase the gender diversity along with other types of diversity, which are also important in our appointments of arbitrators. One of the types of diversity that we think are particularly important is age diversity. We're always looking for younger arbitrators, often first in smaller cases, but I would encourage the younger of you also to apply to be included on the SIAC reserve panel. Finally, and very quickly, because this could be the subject of an entire webinar on its own, we have a number of provisions in the SIAC rules to save time and money. We have emergency arbitrator provisions. We pioneered an expedited procedure mechanism whereby for very small value cases, cases of less than around $4.5 million US, or where the parties so agree, we can put the case onto an expedited procedure, a fast track process that will almost always produce an award within 6 months, often with a summary explanation of the reasoning in the award. The award will still be scrutinized, but it will, in this fast track process, ensure that the party's dispute is resolved as efficiently and expeditiously as possible. We also have an early dismissal mechanism modeled on the ICSID convention mechanism for early dismissal of frivolous or other types of claims that are manifestly lacking in legal merit or manifestly outside the tribunal's jurisdiction. Finally, our rules also contain mechanisms for consolidation, for joinder, for intervention, again, aimed at ensuring the efficiency of the process. We've studied carefully the time and costs that are entailed in arbitrations under both our rules, the SIAC rules, but also competing rules. I'm happy to say that, I'm proud to say that in large part because of the hard work of the registrar's office, Kevin and his colleagues in the secretariat, SIAC arbitrations are materially cheaper and materially quicker than the competition. And that includes in particular, as I said, the ICC, who, as I mentioned, we regard as our principal competitor in the world of global arbitration. We recently released SIAC investment arbitration rules in 2017. You can see the features of those on the current slide. And because I know you're all eager to get to the main topic today, scrutiny of SIAC awards, let me leave it with that. We have a number of physical offices around the world in today's pandemic times. Physical offices may seem a little quaint, a little unnecessary, but historically we found it a useful way to stay in touch with our local constituency. And I can also tell you, I can predict for you that very soon on the left-hand part of the slide, the Americas, one will see a new physical presence of SIAC aimed at ensuring that you in Latin America and others in the Americas have immediate access in your own time zone to an SIAC representative. And thank you very much for that opportunity to hopefully, and not too whirlwind a pace, introduce SIAC to those of you who are less familiar with it. Thank you again.
Thank you, Professor Born. Mr. Kevin Nash, I believe you have also some comments on specific SIAC rules that you may like to comment on.
Sure, and thank you very much for having us, and good evening from Singapore. What we've tried to do at SIAC with some of the features that Gary was discussing is really try to provide gold-class case management and do it faster and cheaper than other institutions. And we've been very successful at that. That's part of the ethos of SIAC, is trying to be at the front of the curve and doing things a little bit differently. Some of the features that we were discussing that have been paramount to this are emergency arbitration, expedited procedure, consolidation and joinder, early dismissal of claims and defenses. But the important part that we're discussing here is that we also have the scrutiny of awards. Now, we can get into more details on how the scrutiny process works, but with some of these features, this can be critically important. So expedited procedure, when an award is due 6 months from the constitution of the tribunal, because the SIAC scrutiny process is a bit more flexible and a bit more nimble, because it's ultimately a registrar scrutiny, we are able to meet those timelines. For instance, if you had a tribunal, for whatever reason, that submitted the draft award 5 months and 28 days, we are able to turn that award down around in a few days to meet that 6-month timeline. A similar thing happens for emergency arbitration. So an emergency arbitrator renders his or her order. By rule, we have to scrutinize all emergency arbitrator orders. So this can take place in a matter of a few hours. We will typically do a concurrent scrutiny. So you will have legal counsel assigned to the case alongside myself or the registrar that are scrutinizing this at the same time. This is often late at night, and the timelines are very quick. So part of the reason why the scrutiny process is so important to us is because we have parties coming from so many jurisdictions. In the last 5 years, we had parties from over 100 jurisdictions that are choosing to bring their disputes to SIAC. Now, while you cannot always anticipate the eventual place of enforcement, particularly in Asia Pacific, there's many countries that have certain procedural requirements for the enforcement of the award. Because we've had so many of these SIAC awards going out to these jurisdictions, we have a pretty good idea of the requirements for enforcement, in addition to the mandatory laws for if the seat is Singapore. So the scrutiny process, we think, is one of the biggest value adds for our users. It's something that we spend an extraordinary amount of time on. And the tension is, and I think that what SIAC has done very well, is being able to do the scrutiny quick enough while still providing the value add for our users.
Thank you for that detailed presentation. It provides great insight of one of the specifics of one of the leading arbitration institutions. Now we will continue with the roundtable section, which includes 3 specific phases. First, we'll be led by SIAC representatives, and they will focus on the scrutiny of awards under specific SIAC rules. So Professor Bourne and Mr. Nash, you have the floor once again.
I'll leave this mostly to Kevin. Scrutiny of awards, though, is an important aspect of what many arbitral institutions do. The ICC, Court of Arbitration, also has a scrutiny process. Some arbitral institutions do not. Some institutions that adopt a light touch towards case administration, the LCIA, for example, do not scrutinize tribunals' awards. I think the better practice among leading arbitral institutions, though, is to have some form of scrutiny. Arbitral tribunals are hopefully diligent, competent, very skilled at what they do. Nonetheless, I think it's important to remember that a little bit like writing a book or a law review article, a little bit like writing a statement of claim or a submission, a memorial in an arbitration, the author always can benefit from another set of eyes, other pairs of eyes who come to the subject matter fresh. And that's why you have editors of books. It's why you have senior partners review submissions. And the same is true with arbitral tribunals. It's especially true with sole arbitrators when you have a one-person tribunal. But it's also true of three-person tribunals. Having a fresh set of eyes, which after all is what the parties will bring to reading the award, and even more importantly, in a sense, what a national court in either annulment proceedings or recognition proceedings will bring to the award. Having a fresh set of eyes, look again at what the tribunal has said without any assumptions or embedded knowledge that one just believes everybody must know. And we find in many cases in the scrutiny process, it's not that the tribunal got something wrong or was confused, but they simply assumed too much knowledge on the part of the reader. And thus, scrutiny in our experience is an extremely helpful process. It's not just a means of catching typos and that sort of thing. It's a means of ensuring real quality control. That said, as Kevin is going to explain, there are different types of scrutiny. And putting it really bluntly, there's faster scrutiny and there's slower scrutiny. In our view, the scrutiny process is very important. You're at the end of a hard-fought arbitration. The parties have submitted their cases and are waiting. I can tell you, because I spend most of my time being counsel, waiting very, very eagerly for the tribunal's decision. You do not at that point want the arbitral institution dragging its feet or causing delays. It's essential that there not be many weeks in the scrutiny process, that it be conducted both high quality but also high speed. And that's where Kevin takes over.
Sure, and Gary, talking about that speed, last year our scrutiny process averaged right around 14 days. So this includes all of consent awards and some awards on multi-billion-dollar major project disputes where the award may be in excess of 500 pages. As I mentioned before, part of what allows us to do this so quickly is because we have a two-stage process. So the legal counsel that has carriage of the case, what's important about this is that this legal counsel is following the proceedings the entire way. It's important from a scrutiny process, no matter how fast you do it, that the person is conversant and acquainted with the submissions. One piece of feedback that we often get from tribunals is how well the legal counsel know the case. To come in afresh without any knowledge of the proceedings when a tribunal has been looking at this case every day, say for 18 months, makes it very difficult to do the scrutiny. So the scrutiny starts early by the legal counsel remaining up to date on the pleadings. We've taken this a step further during coronavirus as well. In the case of virtual hearings, we always have our legal counsel that are sitting in at a virtual hearings. If we're scrutinizing an emergency arbitrator's order, whether in person or virtually, again, the legal counsel who is doing the first stage of the scrutiny is in that hearing, and that allows us to do the scrutiny even more quickly. When you're thinking about the concept of scrutiny, of course, there is enhancing the enforceability of the awards, but it's like Gary says, that you're just having an extra pair of eyes on the process. And it's far more than just an editorial review. So there's almost a formula to it. Because we've issued thousands of awards, we've scrutinized thousands of awards, there's almost a formula to the enforceability. So you're going to look to see if the tribunal has clearly and accurately set out the procedural history. Have there been any procedural irregularities which need to be addressed by the tribunal? Has there been a non-participating respondent or an intermittently participating respondent, which can sometimes be more difficult? Has the tribunal set out the issues in dispute completely and accurately? In ICC, if there's a required terms of reference, but often in SIAC arbitrations, you will have an agreed list of issues, which can be helpful from a scrutiny standpoint to make sure the tribunal has addressed all the issues in dispute, but no more than any of those issues. We also look at to see whether the tribunal has gone beyond their jurisdiction in any of the orders, or any of the orders outside the four corners of the arbitration agreement. Has there been an order against a third party, a non-party to the arbitration agreement? Of course, it's okay for a tribunal's order or award to affect a third party, but not against a third party. Have the parties been given an opportunity to address all of the issues in dispute? Has the tribunal identified the lex arbitrii? Has the tribunal's decision been based on the governing law of the contract? An interesting idea to remember as well about the scrutiny is that we're not there to change the tribunal's mind. The language of the rule is that we have approval of the form of the award, but we can also draw the tribunal's attention to points of substance. So all of our comments and our feedback are addressed in a way to assist the tribunal. It could be the case that a party has submitted on a certain issue, and for whatever reason, the tribunal didn't turn its mind to that particular submission. One common example that we might see, say you had a situation where a claimant had been substantially successful in all of its claims, and the arbitration clause provided that the losing party is to fully bear the costs. Then you have the transnational tradition that costs follow the event. It could be that the tribunal might have each side bear its own costs. So that is absolutely the tribunal's decision. But what we might do is just note the language of the arbitration clause and for the tribunal's better discretion. We are not there to change the tribunal's mind. And in fact, you do not want an institution changing a tribunal's mind. You want the institution just to make sure that every possible procedural element has been followed and that they have looked at all the party submissions. And that's what really the scrutiny process is for. One thing that we look at as well is the body of the award should match the dispositive. If it's a 3-member tribunal, we want to make sure there's coherence. If each tribunal member has been drafting different parts of the awards, we want to make sure there's coherence within the body of the award, and to make sure that the body of award matches up with the dispositive. We've had very good success with our scrutiny process, very few set-asides or successful resistance of enforcement in SIAC arbitrations, but that's not really the only metric that you should use to assess the value of the scrutiny process. There are certain awards, and these are uncommon awards, where there might be a trigger in the dispositive. Say the respondent has to do something before the claimant is able to receive the award. There are awards that are non-functional, not set aside, no resistance of enforcement, but just because the award doesn't work. And so that $100 million award, if there's a problem in the dispositive, now when the parties are talking, the bargain may be much lower. So we are really there just to ensure that we can enhance the enforceability to the highest degree possible, bearing in mind the mandatory law at the seat and our anticipated place of enforcement.
Thank you both for your analysis. It definitely sets a great example on how scrutiny procedures should be held. Now, Alfredo Bullard will discuss the scrutiny of awards according to the ICC rules. Alfredo, you can start.
Okay, thank you. Thank you very much. I'm going to share my presentation. Okay. Well, first, it is a pleasure to share this panel with Gary, Kevin, Waskar, and it is also a pleasure to give the opportunity to our participants, especially those from Latin America, to learn about SIAC, its practice, its relevance, and its relationship between Asia and Latin America, and how SIAC can help to solve disputes in different countries around the world. Well, first of all, I'm going to talk about the ICC scrutiny process, which in some aspects is similar, in some aspects is different. And I will talk about my experience as a member of the court, of the ICC court. The wording of Article 34 of the rules, which you can see in the screen, it provides that all awards, including interim, partial, or final, rendered under the ICC rules are subject to prior approval by the court. The rules clarify that the range of issues that may be raised by the tribunal's arbitral, by the arbitral tribunal, consideration covers the point of form and also points of substance. Form modifications are in some way mandatory. We're expecting that the tribunal is going to take them into account, and point of substance can be only suggested by the court to the tribunal. The main function of scrutiny is allowing efficiency. In the case of ICC, scrutiny allows that over 90% of the ICC awards are adjusted and improved before being issued. So you have important number of the awards that have some sort of change, some have relatively slight changes, but sometimes you have substantive changes because the comments make the tribunal to make the changes. So the ACC suggests that the scrutiny process should take about 2 or 2 weeks. Sometimes it takes longer, and sometimes it takes a little longer, especially if you are facing a difficult, a complex award. No? But in general, it takes around the time that it has mentioned by the ICC. Which are the main purposes? Quality control mechanism, as was mentioned by Gary and Kevin. Justification and improvement of the awards that the losing party might otherwise decide to challenge. No? Protecting awards against its set aside, and favoring the recognition and enforcement before state courts. It is important to understand that the scrutiny process has to be adapted depending on the case. You know? So there is not one size does fit all. You know? You have to understand that every case is different, and as such, you have to adapt to that situation. So we will explain now how it works in the ICC cases. No? The ICC cases goes to the court. The court has a structure that you have a lot of people involved. No? In the court, you have one president, 17 vice presidents, about 115 members of the court. Not every member of the court participates in all the meetings. You have the plenary meeting that usually have around 30 to 50 people participating. The process begins with the counsel heading the case, preparing an agenda with suggested formal improvements. No? This agenda is reviewed by the Secretary General, the Deputy Secretary General, a managing counsel or general counsel that decides according to the complexity and the characteristic of the cases, if they should go to the plenary, which is the main meeting, and you have the participation of, or the possibility of participation of every member of the court, or you go to a special committee that is usually composed by 3 people, the 2 persons, but sometimes you have bigger committees. For example, you can have a committee related with some cases in Spanish, and then you have some members of the court that speak Spanish, and they can be 5, 10, it depends on the situation. And then you go to a reporter, which is appointed by the secretary. Is suggested here. He prepares a relatively short report, takes about 3 to 6 pages, but he comments the agenda and he comments the award. And then in the meeting, he make a brief explanation of his report. If the secretary, want to also make it any kind of point about the award, he can do it. He can do that. And then the court votes and decide if the award is approved or it is disapproved, and in any case, which comments are going to be posed to the tribunal, and the tribunal is going to receive the comments. In most of the cases, in the majority of the cases, you only have comments. You have the award is approved, subject to the comments by the court, and the tribunal have to modify the award to check what the comments means. If they are of form, they have to implement them. If they are of substance, they have to evaluate them. And then the secretariat will check the new version of the award and will decide that it have comply with the comments and have check the comments, and the award can be served to the parties. If it is not approved, you have to go again through the process. You have to go again to the court for a second round or it can be 3, 4. What is needed to have finally an award that can be of the quality that is expected. So the ICC scrutiny process is also subject to deadlines, and if you do not achieve the deadlines, the fees of the court will be reduced, up to 20%. So it's the same way that it works with the arbitrators. If they do not achieve the deadlines, they will have a reduction in their fees. That's the same happened with the court. There is a checklist which is very detailed, and you can, if you want to prepare your award, it's good to take a look so you know what is the kind of things that the court is going to check. And I will mention here some of the examples of things that the court is looking at. For example, that an arbitrator may not introduce new facts, arguments, nor legal exhibits that were not being directly discussed by the party. So there is nothing strange or new, or there is not a surprise for the parties that the tribunal came out with some argument that nobody have discussed during the whole case. So that is something that you check, and you ask to the tribunal to be more specific where it was discussed, if it was discussed, or even if you have to change the motives of the award to follow what the parties really discussed. Consistent motivation throughout the award, that you can understand what the award is saying, that it is clear that there is consistency between the dispositive and all the reasoning in the award. The award should be self-explanatory. That means that you only need to read the award to understand the case, and you can understand the reasons of the decisions only reading the award without the need of reading the whole case. So anybody that is not familiar with the case can understand what the case was about, and which was the kind of discussion that the parties had. Consistency between the terms of reference and the award, so you know that the award is deciding about the points that the parties are in conflict. The analysis, if a dissenting opinion puts in the award at risk, and if effectively it is needed to have a change maybe, or an adjustment in the award to be more responsive to any kind of argument that the dissenting opinion may face, may put then, and so you can understand better what the award is in a better position in relation with the dissenting position, the dissenting opinion. Sometimes checking even the arithmetic calculation to see that there was no mistake in how do you calculate interest or damages or any kind of number, and check if the main arguments of the parties have been addressed in the award. And now I'm going to talk, and that's my final slide, about the value of wearing 2 or sometimes 3 hats. As I mentioned, I am a member of the court right now, but I'm also an arbitrator in some cases under the ICC rules, and I'm also a lawyer, a counsel in cases where I act as representing one of the parties in an ICC case. So I can see scrutiny from different points of view. First, I will say that as a member of a court, I have learned a lot about arbitration, seeing the discussion among the members of the court about the different issues that you have to face, and that is something that is very useful for my practice. Second, as an arbitrator, I can clearly say that I'm more demanding in my own practice as an arbitrator, because I know that I'm going to have an scrutiny, and that means that you only have the benefit of having the scrutiny itself, but also the incentive to be more cautious about how do you do work, spend more time and look at all details, because you know that you are going to have this scrutiny and your work have to be done in a better way. And that have an indirect effect in other awards of other institutions, because you learn how to take care of the award and all the issues that you will have to face. The comments of the courts are usually very thoughtful, very clear, and really you notice that there is something that can be improved, and my experience is that you always improve a lot. a counsel, first, one of the things that I used to advise to my clients is try to have a center that have an scrutiny process. That means that you have an additional quality check system that will improve the work. And second, even in my practice as a counsel, scrutiny is not only scrutinizing the work of the tribunal, it's also scrutinizing in a way the work of the lawyers that have participated in the case. If you want to have a better award, if you are a lawyer, you have to be clear, persuasive, and you have to study the case. And that will help the arbitration tribunal to make a better work. So you feel sometimes when you're in the scrutiny process that lawyers have helped a lot to easy the work of the tribunal, and as such to easy the work of the court, because a clear award is not only the product of the tribunal, it's also the product of the lawyers that have participated during the discussion. So in any way, it's a win-win process. You will see that everybody who is participating will receive a better product, will have a better opportunity to make a better job. And the scrutiny in that perspective is something that I think is very important. And I think adds significant value to the arbitration, to the award, and to what the parties are looking for, that is to solve the dispute. So thank you very much, and I'm available for questions at the end of the workshop. Thank you.
Thank you, Alfredo. Your experience shows that the ICC scrutiny system is definitely one of the main features that guarantees its institution's success. The last section of this roundtable will be led by Oscar Escurra, who will focus on the scrutiny procedures in Latin America. And after that, our panelists are encouraged to discuss on each other's presentations.
Thank you, Jimena. Good morning, everybody. Good evening, Kevin, and good afternoon, Gary. Thank you both for the opportunity of having this webinar with you guys, and especially for the opportunity to learn about SIAC experience. The objective of my presentation is to try to take advantage of what you just said and try to think about how we can improve the Latin American arbitration market. No doubt in Latin America, the arbitration market is growing. In this report of 2018, 56% of the lawyers interviewed reported that more than 50% of domestic commercial contracts in Latin America include arbitration agreements. Arbitration in Latin America is growing, and I am sure it will grow even more in the following years. So my question will be, are we doing what is needed in order to get what Kevin defined previously as gold class case management? Are we providing the users or the customers of the arbitration system high speed and high quality, as Kevin just explained? No doubt, arbitration users prefer institutions with award scrutiny system, as the people, as the attorneys or the arbitrators who were asked the question, what are the 4 most important reasons for your preference for certain institutions? The answer was, among others, a scrutiny of award by institution. No doubt, arbitration users are looking for higher quality. No doubt, a scrutiny process will bring them higher quality. Why do users prefer or will prefer an institution with a scrutiny system? They will prefer that because it maximizes the legal effectiveness of an award, reducing the risk of its annulment, avoids tribunal missteps, protects the parties then, reduces requests for integration or exclusion of the award, and allows an institution to have some degree of oversight over the proceedings themselves. However, even though arbitration is growing in Latin America, it is very interesting to see that in Latin American countries, there are just 2 arbitral institutions that have a quality control system of the awards and a scrutiny system. Only the CAM in Mexico and CEMARC in Argentina have a scrutiny system of the awards. I think we do need more of this in order to improve the Latin American arbitration market. But in a way, I will say that the problem to have this quality control system is a cultural problem. In a way, in my view, the first problem has to do with the culture we do have that has been, I will say, transferred by the ordinary justice culture. In which sense? The culture in ordinary justice system is that judges are autonomous, and that's fine. They have to take care independently about the substance of their decision. However, in our culture, we understand that autonomy has to do not just with substance of the decision, but as well with the service itself. And I think that is the problem, because autonomy should be understood in the sense of substance, but not in the sense on taking care of the service. If we move to the arbitration system, in my view, we need to consider users of the system as customers. And usually, as in other industries, customers are right. And in this market, in the arbitration market, customers demand higher quality. Customers demand higher speed. And then we need to see arbitral institutions as companies. Companies need to take care of the service itself, of the efficiency of the service. Companies need to take care of the quality of the services. That is why, as in other industries, in the arbitration market, arbitral institutions need to take care of the services provided in terms of higher speed and higher quality. Customers expect awards with higher quality. Then the company, which is the arbitral institution, need to take care of that part of the service. So if we are able to change culture, and if we are able to introduce the scrutiny system in more Latin American arbitral institutions, we should follow these 3 steps in order to do that. First question we need to respond is, who should be the body in charge of the scrutiny process? As my previous colleagues explained, there are many options. In Peru, for example, if we talk about the Chamber of Commerce of Lima, the Center of Arbitration of the Chamber of Commerce of Lima, well, one question to respond will be if this work should be in charge of the Court of Arbitration, or if this work should be in charge of the General Secretary and its secretaries, or if it should be in charge of someone else. I'm not sure about the answer to this question. However, we should consider, in order to be able to find an answer, that the Chamber of Commerce of Lima has around 800 procedures per year, and the number of awards issued per month is around 30. So if we consider that 10% approximately of those 30 awards issued per month are of complex cases, just 10%, we're talking about 3 awards per month that need a complex process for the scrutiny of the award. And the other maybe can have a more fast-track process for the scrutiny of the award. We need to think about it. Okay, we need to design the process, as Alfredo explained before, depending on the complexity of the case. And complexity differs from one case to the other. So in my view, it is possible to make a system that fits to the need of arbitration in Peru. Once we respond to the question of who should be the body in charge, we need to respond to the question of how should we design the specific scrutiny process. We can have different sizes for different type of process. And of course then, as a third and very important step, we need to change culture. We need to make people understand that the role of arbitral institutions should be as the role of any company. Arbitral institutions should take care of the quality of the services they provide. And that has to do with dialogue, and that has to do with educating the arbitration community and promote this type of quality control systems. So, do we need quality control of awards? For me, it's very clear that customers tend to prefer more quality rather than less quality. Customers tend to prefer quality control. In fact, they do expect that companies do quality control. Arbitration customers expect then to receive awards issued in a form they can enforce. So if we were to provide arbitration customers with what they expect, quality control of the formal elements of the award is a key element of the services. In conclusion, award scrutiny is a must-have. How to get started then? How to be healthy and survive when designing this scrutiny system? Arbitrators will not feel comfortable if someone else reviews their work. That's true. I mean, that will happen. Then the seniority of the authority responsible of the scrutiny process is needed. It's a must as well. Arbitrators shall respect the authority that will review their work. Their autonomy will be at stake? I don't think so, not really. Parties appoint them and want them to be autonomous, but at the same time, parties want the draft of the award to be reviewed in formal aspect, not in substance, so that it can be enforced. There is no such conflict with autonomy in my view. To the contrary, parties' autonomy choose to have the scrutiny process. So what we need to do is let the innovation and the discovery process start, make the change, and I am sure in the near future, the arbitration market in Latin America will be better. Thank you very much.
Thank you all. I'm sure it has been very interesting to all to hear about SIAC as an arbitration institution, its particular qualities and success, as well as from different scrutiny procedures and the actual situation on different countries. I'm sure you want to comment maybe on each other's presentations. For example, Mr. Kevin Nash and Professor Bourne commented on the special comparison between costs on the SIAC rules. maybe how would you suggest to apply these rules for different institutions that do not have a scrutiny procedures? And how can we adapt to create an effective system?
Perhaps I'll jump in and answer that. I agree very much with Alfredo and Huáscar that scrutiny is not a nice to have. It's not an interesting accessory that is helpful. Instead, I do think that scrutiny is a necessity. It materially advances the quality of the decisions, which in turn, I think, better serves the parties' desire to resolve their dispute in accordance with the rule of law. It enhances the enforceability of the award, and it, in general, just materially improves the arbitral process. I do think it's, and therefore I don't think it's a nice to have. Instead, it's a must have. I also agree that it's worth thinking hard about how best to deliver scrutiny, both for Latin American institutions, but for that matter, SIAC and the ICC. Although scrutiny is a must have, I think another must have is efficiency in the arbitral process. And if scrutiny drags on, it's hard to say. Every case is individual. There's no one size fits all. But if scrutiny drags on, especially at the end of proceedings when parties are expecting a result, it can undo many of the positive benefits that the scrutiny process is meant to provide. I don't know whether the tipping point is 3 weeks or 4 weeks or something longer, but I think when you're in that region, except in very exceptional cases, you're really beginning to undo many of the benefits of the scrutiny process. What that means institutionally, going back to some of Huáscar's question about how you design this process, I'm not sure. Perhaps every institution is different. Perhaps every institution needs to, in light of its own particular internal structure, come up with the most efficient way. I do think, though, that just like clients want a lean team of litigation or arbitration counsel to handle their case as party representative, so one should have a lean team in the scrutiny process. I would hesitate to have dozens, or for that matter, even a dozen people involved. A second pair of eyes doesn't mean a second 100 pair of eyes. And inevitably, the number of people that are involved, I think, leads to delays, and in some cases, I think probably even undermines quality. If there's firm responsibility assigned with a specified number of individuals, I think it's likely they will perform their mandate better than a large committee would. Again, though, it's, I think, a choice for every institution in light of its internal structure and its particular market segment. I do think it is something every institution ought to think about. I'm sure there are ways that the ICC, I'm sure there are ways that we at SIAC could improve our scrutiny process. And I think it's a very good comment that one should think about how to design that process.
Thank you. Alfredo, I believe you want to comment. You are on mute. Okay.
Yes, I have some comments and really a question to Kevin and Gary about how to implement a scrutiny system. The scrutiny system, yeah, it takes a special relevance in a system as arbitration where you don't have an appeal. You don't have nobody checking. Really, you only have the challenge. And I think it's a good way to work, having not an appeal not having an appeal in arbitration. But on the other hand, that faces the problem of how to check the quality. One of the functions of an appeal court is to check the quality of what you did and how do you decide a case. It's not the same, it's different, it's a different process, but it's trying to improve the quality. And I agree with all of you that it is a must. I think that we have to work in a must. But I want to comment in the situation of Peru that is in some way similar and some way different to other countries in Latin America. Peru is maybe, it is impossible to measure that, but maybe it's the country with most arbitration cases per capita in the world. For different circumstances, we have a lot of cases, mainly because there was a very friendly attitude of the state for many years. Every contract enter with a state entity or with the state has a mandatory arbitration clause according to the law in Peru. So that means that we have a big number of cases. And taking a scrutiny, for example, in the Chamber of Lima, in the Chamber of Commerce Lima Center, means as Oscar mentioned, a big number of cases. SIAC has been a very successful example. It's a relatively young institution with a scrutiny. Scrutiny means costs, which means that the cost of running the center is higher because you have the scrutiny process, but you have delivering more quality. So, and you have been successful as your numbers show. So maybe you can give us some input about that. What about having at the beginning a system that the parties can choose of having or not scrutiny? For example, the arbitration, you can have two different arbitration clauses. You can have an opt-in, an opt-out system. You can choose to have, or you can choose not to have, depending on how you structure the rules, and let the market decide it. You have different costs, of course. You have with scrutiny, the table of fees is this. Without scrutiny is that. Do you think that's a good idea for a young institution or for a institution that have to change and have a scrutiny process to implement, or you think that it is better to have only one alternative and try to make it efficient? It will have an impact in cost. That means an impact in fees, but it worth the effort to do that. Gary,
Alfredo, that's a great idea. And believe me, one that we have discussed quite specifically at SIAC in recent years, whether we should have a sort of business class and economy class approach towards scrutiny, which, you know, in one theory would let parties better tailor the procedure what they actually want. And party autonomy is one of the foundations of international arbitration, so why not? We ultimately, at least for the present, decided not to. We're in the I think 7th rule revision right now. We last revised the SIAC rules in 2016, and we're in the process of now revising them once again, make sure that they're at the forefront of best practices and institutional practice. We're certainly open to hearing either on this webinar or otherwise during our public consultation process views about how we should approach scrutiny. For that matter, we're interested in hearing about any aspect of the SIAC rules. But we decided that if we made that an explicit choice, parties can pay more and get more scrutiny, then parties would feel like they were getting second-class justice in those cases where they didn't pay more. And, you know, put most simplistically and maybe not entirely fairly, that there'd be one quality of justice for parties that are well off and another quality of justice for parties that don't have so much money, and that wasn't something that was consistent with what we aspired to do. That was part of our thinking. Another part of our thinking, though, was, in a funny way, we talk about scrutiny as a kind of monolithic, uniform thing. There's scrutiny at the end of the award, and it's the same, one size fits all. But in fact, in practice, that's not how it works out. When you have, for example, the expedited procedure cases, which tend to be small value and also tend not to be very complicated, the awards tend to be pretty short. In fact, as I mentioned very, very briefly, as I described the expedited procedure process, the awards can even be in summary form there with respect to the reasoning. In all those cases, it's natural. It's almost inevitable that the scrutiny process be a lot quicker. Parties don't need, in a sense, to opt into something that is more expedited or that is cheaper, but it's inevitable. It's a little bit like if you paint a really big house, it takes a long time, but if you paint a small house or just an apartment, it doesn't take you as long. It's the same scrutiny process. And so at the end of the day, we thought that there was a kind of self-regulating mechanism that would ensure more scrutiny in the more complex cases, less scrutiny in the less complex cases, and on balance, especially given that we have an ad valorem amount in dispute fee system, that all roughly made sense. There's one other point that I'd like to make while I'm on the topic, this general topic, which is that in a way, scrutiny happens all through the arbitral process if you have a good registrar and secretariat. And by that I mean, not so much scrutiny of the award, but scrutiny of the arbitral process. The secretariat is there to answer questions, not just from the parties, but also from the tribunal. The secretariat doesn't intrude in the running of the arbitration any more than they intrude in the decision-making of the tribunal. But they're there a little bit the way the ICSID counsel are in an ICSID arbitration, to provide objective facts about how the rules work, to call to the attention of a young tribunal member, or perhaps not so young tribunal member, some rule that she or he might not have focused on, to perhaps neutrally report on how some other tribunals have approached similar issues. Not to influence or much less dictate what the tribunal should do, but to identify for the tribunal things that parties counsel might not have done, so that the tribunal can have in mind all of the various aspects of the procedure, the arbitral procedure. And in a way, that's a type of scrutiny that makes sure that when you get to the time of really scrutinizing the award, everything's been done as well as possible.
Thank you so much for your detailed explanation. Now we will continue with the Q&A section. At this time, the chat section will be available for any of our attendees to ask any questions they see fit to our speakers, and I will try to select as many as I can given our time limit. So we have our first question to Professor Born, and this is, do you see that SIAC as a strong, viable option for Latin American parties in commercial and trade relationships with Asian parties, especially those from China, South Korea, and India?
Thank you very much for that question. And I'll bet everybody who's participating knows what my answer will be. The answer is yes, I do. I think SIC is perfectly situated as a small common law jurisdiction, but with a strong familiarity with civil law from the civil law jurisdictions in the region to administer in an objective and neutral way disputes between our main Asian users, India, China, Japan, Korea, Philippines, Vietnam, and Latin American countries. We're trusted as being neutral by countries in the region. If you have an India-China dispute, a Philippines-Vietnamese dispute, we're seen as a little bit the way Switzerland is seen in Europe as a neutral venue. Equally, we're seen as, Singapore is seen as a neutral venue. SIC is seen as a neutral institution in disputes between Asian parties and North American parties and European parties. And I see no reason at all that we shouldn't be seen in exactly the same way in other types of contracts between, on the one hand, Asian parties, and on the other hand, Latin American parties. The Court of Arbitration, which is responsible for appointing the arbitrators, is truly international. Myself as president, and vice presidents like Lucy Reed, I think have complete neutrality and independence, as do the other members of the court and the members like Kevin of the Secretariat. There's only one further point that I would like to make, which is that I don't think SIAC is perfectly situated only for Latin American versus Asian disputes. I would say that we're equally well suited, indeed, perhaps even better suited, for Latin American disputes with European parties. In those circumstances, the neutrality of Singapore and SIAC is I think, unquestionable. Singapore stands as a trusted, small but entirely neutral jurisdiction. SIAC similarly situated. If you have, for example, a contract between a Peruvian and a French party, why wouldn't SIAC seated in Singapore be a more neutral choice than, I don't mean to put Alfredo on the spot, but ICC seated in Paris? More for that matter, ICC seated across the border in French-speaking Switzerland. I would even suggest that for purely Latin American disputes, if one wants to avoid any questions about whether CAM in Mexico might be more favorable or less favorable for one party, for the CAM CCB in Brazil would be more or less favorable. SIAC is a truly global institution, able to handle disputes in Spanish on a purely Latin American basis.
Okay, thank you for your answer. We have another very interesting question for both Professor Born and Mr. Nash. And this is, should the members of the arbitral tribunal know who has made the scrutiny?
I can try to answer that quite quickly, and it's similar to what Gary said about the appointment process in that it's very transparent. So at SIAC, the scrutiny process would be transparent to the tribunal members. It would be case counsel with the first level of review, and then me or the registrar with the second level of review. So the tribunal is aware, and it sometimes is an ongoing conversation between the tribunal members and the Secretariat as we're approving and addressing the comments that we have in the draft award.
Okay, thank you. We have another question for Professor Born. I believe you've already mentioned this slightly, and it is, what is SIAC's relevance in Latin America? You've mentioned that it will be very suitable for disputes between Latin American and European countries. So how you think it can influence any arbitration institutions in Latin America? For example, I've learned different SIAC rules that aim to reach an efficient administration, for example, consolidation and joinder rules. So how do you believe this impacts on other institutions?
That's a great topic, and it could, I think, even be a separate webinar series. I think all arbitral institutions should cooperate together. In one sense, we're competitors. I think Huáscar's presentation pointed out how our customers want certain things, and like other businesses that provide services, we in a sense compete for users to adopt our specific rules. But while we're competitors, we should also collaborate in ensuring that we all jointly fulfill our common mandate, our common mission of resolving disputes in accordance with the rule of law as best we can. We have things to learn from other institutions. I know we, for example, consulted with ICSID about adopting its early dismissal rule, and we've been happy to consult with other institutions, including going the other direction with ICSID about their recent rules revision. We stand open. We have open arms and open door policy to to any institution in Latin America and Peru that would like to discuss any aspect of arbitral institutions. One specific topic that we broached a couple years ago and are still working on is the notion of cross-institutional consolidation, the possibility of consolidating arbitrations being conducted under two different institutions' rules into a single proceeding. It's not necessarily the most common occurrence in the world, but I can tell you from my own practice, it does come up more frequently than one would think, and it can involve, because of duplicate proceedings under different sets of rules, real risks of inefficiency, inconsistent results, and the like. SIAC made an open proposal to the ICC, to others, to study this possibility, to study it seriously with a view towards finding a solution, a practical, pragmatic solution consistent with the parties' intentions of ensuring that parallel proceedings could go forward in the most efficient possible way. It's an invitation that still stands open. Happy to consult with Latin American institutions about either that or any other topic that could be of interest to them or of mutual interest.
Thank you. We have another question for Mr. Nash. And this is, which are the costs to have a scrutiny system? And do you believe that the benefits of having such systems surpasses those costs?
There certainly is a cost-benefit analysis to the scrutiny process. And as many of the speakers have been saying, at what point is there the tipping point where the scrutiny process is taking too long? But if you actually look at the SIAC system, which is similar to the ICC system in terms of there being fixed tribunal fees, a scrutiny process done right should not cause any additional cost. In fact, it may take away some cost, so there might not be a correction, an interpretation, or an additional award. But more importantly, because we're fixing the fees of the arbitrators and the institution out of these, on this ad valorem system, it allows us to really do the forensics on the case to determine what has actually happened in the case. Same way as the ICC, if SIAC is slow on the scrutiny process, we will pay ourselves less. If a tribunal is slow on the scrutiny process, we will also tax the tribunal fees. And this helps us, because we're reviewing the awards, this helps us appoint the next time this arbitrator is appointed. We have a better idea of who are the best arbitrators in the world, who is able to marshal and efficiently run these complex cases. So the hope is that it should not add to the cost and should not have any unbargained for delay. And that's why we are very careful, even with these complex cases, 500-page awards, of making sure the scrutiny process is done in an appropriate amount of time, where it's not going to add to cost, but it is going to enhance the enforceability of the awards. From an institutional standpoint, you do have to think about your resourcing. We have 12 legal counsel qualified in jurisdictions all around the world, both common law and civil law, because we probably spend more time on scrutiny than we do on anything else. And we have to make sure that our resourcing is properly allocated, because as Gary was saying, really scrutiny starts at the outset and structured administration starts at the outset. So we have to be monitoring and overseeing every element of the arbitral process. It's not just at the conclusion of the proceedings, it's all the way from commencement, making sure that the parties have been properly notified of all of the most important procedural steps in the arbitration. You might have a case where there's 3 or 4 awards. You could have a decision on jurisdiction, multiple partial awards. It could be bifurcated or trifurcated. So it does take some experience to streamline your scrutiny process to make sure that the institution is paying attention and assisting the parties in the tribunal all along the way.
Okay, perfect, thank you. We have one final question, and this is, in an imagined cross-institutional proceeding, wouldn't the situation arise where one institution's rule would benefit one party and that party would want to adopt that rule and the other party would object? And how would one resolve this type of procedural dispute?
I think that's probably for me.
Yeah.
It's a great question. The basic concept of the cross-institutional consolidation proposal is as follows. The two institutions that wanted to collaborate together, to work together, for cross-institutional consolidation would each include a provision in their rules that the parties agreed that in circumstances where there were parallel disputes under different sets of institutional rules, a cross-institutional protocol would apply. And so the parties would have consented to the terms of that protocol that would set out what happens potentially in cases where you have parallel proceedings under, just by way of example, SIAC on the one hand, ICC on the other hand. What exactly would be in the cross-institutional protocol would obviously depend on what the two institutions negotiated. In my view, there would be a couple possibilities. The parties could make submissions and they might, for example, both agree that we'd rather proceed under the SIAC or alternatively the ICC rules, in which case the protocol would provide that whatever the parties sort of opted into by way of an amended arbitration agreement would apply. If the parties didn't agree, and Jimenez, I think you're right, in some cases parties might well not agree because they would see some advantage to one set of rules as compared to the other. In cases where the parties did not agree, the cross-institutional protocol would set out a mechanism for selecting the proper set of institutional rules. Put differently, a mechanism by which one arbitration under one set of rules would be consolidated into the other arbitration and thus take on and be conducted under that institution's rules. The mechanism could be a simple one based, for example, on the amount in dispute. Whichever arbitration was bigger is the arbitration that would take over, if I can put it that way, the other arbitration. Alternatively, you could have a mechanism that provided whichever arbitration was started first, the first filed rule. The second arbitration would be consolidated into that. Alternatively, you could have a decision-making process where the two institutions had to both agree after the fact, when two arbitrations arose, that one or the other institution's rules would apply. That would require cooperation by the institutions, and it would also require agreement in particular cases. I'm fairly confident that the institutions would in fact cooperate in good faith. I'm not so confident that in every case that would produce agreement. But if it didn't, if only some cases were consolidated, that would still be a better place than where we currently are. Even if institutions might in some cases say, we just can't fairly consolidate these two cases, that's not so different from consolidation under existing rules of one institution, where in some cases you don't consolidate because of inefficiencies or other matters that might arise from consolidation. And so the basic concept of the consolidation protocol, the cross-institution consolidation protocol, is it would set out neutral rules to be objectively applied that will decide which institution's rules would govern the new consolidated arbitration. Hopefully that would produce efficiencies for everyone. And hopefully all institutions would share the goal of realizing those efficiencies.
Great, thank you for your information, Professor Bourne. With that, we have concluded our final section for today's event. I would like to thank all of our speakers for your time and insights. It has been a pleasure to learn from all of you. Finally, Wahkar, you and our speakers can deliver your final words.
Very briefly, just thank you, Gary. Thank you, Kevin, for the opportunity. I did learn too much today about the scrutiny process and SIAC. Here in Latin America, we can learn very much from the most prestigious arbitral institution of the world. My conclusions today after listening to you both is that customers in the arbitration market do expect awards that can be enforced, as simple as that. And for that, they do expect arbitral institutions to do quality control. They pay for that, I will say. They do expect when they go to an arbitral institution something in addition they will not get in ad hoc arbitration, and that is quality control. In that sense, this is a must-have in Peruvian arbitral institutions. Of course, this will be costly. Of course, there are challenges, but I'm sure we need to get started. In the process, we will learn, we will discover the best way to do things. Trial and error is needed, as it happens in companies. But at the end, our market will be better if we start the sooner. So thank you so much for all your experience and your generosity today.
Well, if I can just very, very briefly from SIC's perspective, thank both Huáscar and Alfredo and also Jimenez for the very, very kind introduction and also the very stimulating discussion. I don't think scrutiny has ever been scrutinized so carefully as in this webinar. And I look forward to future opportunities to discuss with you and the many participants that we had the honor of presenting to other issues in international arbitration. Thank you all again.
Thank you all, and I hope we'll see each other soon.
Thank you.
Bye. Thank you.